Good afternoon from Nairobi, Kenya at the Lawyers Hub, and happy World Intellectual Property Day. We hope that you are celebrating all the intellectual property that you have had, you may have, and you will have in the future. My name is Linda Bonyo. I am the CEO at the Lawyers Hub, and we're really happy to be having you here today. Thanks for joining us. We look forward to such an action-packed and insightful session this afternoon. And I want to invite you to let us know who you are, where you're joining us from. Please go on the chat and let us know, this is my name, this is where I'm joining in from. If you're joining from Kenya, please let us know. If you're joining from the rest of the world as well, let us know where that is. We'll be really happy to have you. If you have a question, feel free to write it on the Q&A tab. If you have a question, don't put it on the chat. The chat is for networking and letting us know what you do. But if you have a question, please put it on the chat. If you have a question, put it on the Q&A tab and let us know exactly where what we can answer today. I'm really happy to have you as well here. The team at the Lawyers Hub is excited. Together with our partners today, we're really happy to be having you today. We have DJ Coman, who's a really great fan, and we thank you so much. Greetings from Nairobi. This is DJ from Power Internet. Sheila Mbole is joining us from Nairobi as well. Dr. Isaac Rutenberg from CPIT at Strathmore University, thanks for joining us. Kahara Njay here is Fred from Nairobi, thank you. Paul Kaunda all the way from Shinyanga, Tanzania. Angela Mwikali from Machakos County. Farai, oh my God, okay, I'm losing track. Tom Nyarange, Imelda, Go Nairobi, Christina Kuto, Muthoni Kamau, Ashley Kibali, thanks for joining us. Crispin Bosire from Simba and Company. Ali Onyango of Aliam Technologies, Lynn Mudoni as well. Thanks for joining us. Maurice Otieno from Baraza Lab. That's really good to see you here. Caroline from Kenyatta University. Wasim Mohamed Ali from Olka Kontos. Brian Obilo, who's a Mozilla Fellow. Thanks for joining us. Rosaline Vuguta from Nairobi. Gideon joining in from Riara University. Thanks so much. Irungu Kelvin from Nairobi. Victor Mulindi, who's an advocate. Thanks for joining us. Gideon Kibet, Wycliffe Omondi from Bupas. Thanks so much. Victor Sang, Ventura Kireki, Elvin Apio from Kipi, thanks for joining us. Aluo Jane, Michael Kanyi from ADN, thanks for joining. Samuel Wafula, Lorian Mona, Joan from Kigali, thanks for joining. Ajuang Thum from Mombasa, Kelvin Mwaniki from Oloch Kimori Advocates, Michael Mubea from Dublin in Ireland, thanks for joining us. Sophie Mburu, an advocate, thanks for joining. Sian Sairo from Siana Law Global, thanks for joining us. And Mary Flavia from Nairobi, who's an advocate. Thanks for joining us. I tried to read most of them. Thank you so much for joining us, guys, today. If you're on Twitter, please follow us at Lawyers Hub Kenya, and our partners as well will be sharing their Twitter handles so that you can be able to follow them and interact online. And I see Fred Aguel, who's been a really great fan as well of the Lawyers Hub. So thank you for joining us today. If you have a question, feel free to use the Q&A tab and use the chat to interact. So we'll be reading some of your chat messages even as we go along. But today we want to talk about how do you get your ideas, from just being ideas in your head to market. How do we commercialize intellectual property? And so before we begin, we're just going to have two poll questions that we're going to ask you today. And I want to have you answer this honestly. First of all, what word best describes you? We have a few seconds to answer this. We just want to understand who's in the audience today. What word best describes you? Are you a legal practitioner? Are you an entrepreneur, an artist, media, government, academia, or other? There are people who keep picking other every single time, and you haven't told us who it is that we, what demographic we left out. Please let us know. So please just answer the poll very quickly. Which of this best describes you? And I see people still typing on the chat. Thanks, Makena Kinoti, for joining. Rehab Gatwiri, who's an IP lawyer. Thanks so much for joining. Claire Baraza, listening in from Nairobi. Richard Odongo from Anjarola and Kana LLP. And we also have Elijah Ngotho tuning in from Nairobi. Thank you very much for joining us today. I think our first poll question is done. And so this is interesting. We've ended the poll. And so we have 61% of you are lawyers. Entrepreneurs are 18%. Interesting that lawyers do not identify as entrepreneurs first. Artists at 5%, the media 2%, government 3%, academia 6%, and other is 5%. Please, if you signed up as other, let us know who are these others that we keep forgetting about. Are you from civil society? Where are you at that we haven't really figured out? We go to our second poll question, and this is a final poll question, and we want to ask you, have you registered your intellectual property? Have you registered your intellectual property? Yes, no, I don't know. We have a few seconds to answer that question. Please let us know. Have you registered your intellectual property? We have a few minutes and then we'll be done. Fred Guara is an entrepreneur as well who's joining us. Thanks for joining us as well. Have you registered your intellectual property? I think we can close the poll. We have 65% of you have voted. Wow. Have you registered your intellectual property? Yes is 17%. No is 77%. I don't know is 6%. I think that's a really great place to begin the discussion this morning. And I want to invite our guests this afternoon to speak to us. The program for today's session is going to be posted on the chat. And so you'll be able to see the program and follow up on what we are discussing this morning. But our first speaker this afternoon is going to be from the Kenya National Innovation Agency, the CEO, who's Dr. Tony Omwansa, and we'd like for him to make his remarks at this World Intellectual Property Day. Dr. Tony, karibu.
Asante sana. Can you hear me?
We can hear you, though it's a little low. Okay. Just proceed. We can hear you.
Maybe I move a little. I can hear me. Thanks very much. I've moved a little closer. I hope I can be seen. So thanks for the privilege. We are on leave, but because of how important this day is, we are all hanging out. And as I can see, a number of other panelists, no one is in a tie, so that's fine. Yeah, so I come from Kenya National Innovation Agency, which is probably a young agency that is not known by many, but really sits at the heart of this discussion of moving ideas to market. I joined about 6 months ago, and the agency was established by an act of parliament of 2013, but took a bit of time to operationalize, and has been running with an acting CEO until I joined. And we are beginning to get our sleeves up and running so we can have the impact that we desire to have. Now, what is a little striking is what is the mission of the agency. The mandate of the agency is to develop and manage the Kenya National Innovation System. When I look at the mission, it simply says to develop a dynamic, develop and manage a dynamic national innovation system that facilitates moving or taking ideas to market. So right at the heart of what we do, or we should be doing, is exactly what this discussion is about. Now, sometimes it's a question of why, or why is it that we have some kind of a big gap? In trying to explain that gap, I probably look at some of the key priorities that we've identified. After looking at all our functions and spending a bit of time in office, we've picked commercialization as a high priority focus area. And second is the supporting of the startup movement. When we say supporting these two areas, we are focused around the regulatory framework and the legal and the policy issues around this. We're also looking at enabling an appropriate environment in terms of the infrastructural support, and then the issue of putting funding and the mentorship and the coaching and the growth of the incubation framework in the country, besides the commercialization, so to speak. And then also enhancing the visibility of the startups as well as the programs. So in a way, we've kind of carved our focus over the next several years to support the commercialization and the startup agenda. There is a reason why we picked that, because we know that for those of us who are from Kenya, we know about the three agencies that were established by the Act of Parliament of STI 2013, the National Research Fund, the NACOSTI, and the Kenya National Innovation Agency. There is a gap in the context of the commercialization of research. A lot of funds are actually going into research, and that's really not news to many people. But when it comes to invention disclosures, the assessing of commercial value, protection of that intellectual property, or the developing appropriate business models and business plans of those inventions, there is a weakness there. Part of that weakness has to be, it has to do with the national framework guiding commercialization, and then institutional policies and obligations and incentives, then down to individual incentives and obligations. And once we fix this, then we can start gravitating towards getting more joint ventures, spin-offs and startups and so forth. The other day, someone asked a simple question. He asked me, what is the incentive of a professor to build a startup or a researcher to actually establish a startup? Then of course you're like, okay, it's not absolutely very, very clear. Maybe there might be a conflict of interest if they go into commercialization, or they might spend too much time doing that and not be able to do their teaching and research and so forth. Now, of course, Kenya also has a mandate into private sector, into government and into individuals. We don't just deal with the universities only. But I have a simple definition of commercialization, which I like people to think about. It is the process of introducing a new product or a service and making it available in the market. That's it. So it is a process, and not starting from the intellectual property all the way to issues like licensing is what we should be thinking about. And I think we have a room to make a lot of improvement in how our national systems work. And then I think the other area that I haven't felt a lot of strength is around licensing, the mechanisms of technology transfer to licensing, innovations and inventions to for-profit companies that can help further develop some of the products that we may be having into commercial value. For Kenya, we will only measure our success in how many ideas got to market. So it is of interest that we develop our systems in place and we collaborate more in order to get a number of these results into market. In conclusion of my key remarks, and I look forward to hearing a lot of engagements on this and figuring out how to support. We've set up a few things for the next 1 year. One, working with the likes of Lawyers Hub, Riara University and others around revisiting our policy environment, our national legal policy environment. And we expect to have some outputs. We have some stakeholder engagements coming up, and we hope that by the end of the year, we will have kind of cleaned up this system and have the appropriate instruments that strengthen and enable that commercialization process. The second thing that we're looking to do over the next 1 year or so is growing an innovation fund. So we've made case to Parliament around establishing an innovation fund that will focus on, one, supporting institutions in establishing technology transfer programs and incubation programs. Two, scouting promising innovations that could be scaled. Three, facilitating the scaling of those innovations. And I hope in one way or another, we all will get an opportunity to participate. The last thing I want to mention to you is that we are laying a foundation for what we call Kenya Innovation Week. And this will become a flagship program or initiative for celebrating innovations, as well as and we've set the first one to be between the 6th and the 10th of December. And the theme is going to be basically revolving around everyone is an innovator. So it's like the innovator in you, all right? And we want to focus on 4 priority areas. One being commercialization and thinking through the business models and the tools and instruments and so forth. And second is around the skills for innovation. What do we need to strengthen and how are we doing in enhancing the necessary skills? Number 3, we're going to focus on 4th industrial revolution and the technological issues that go with it. And then finally, we're going to look at the startups movement. So along those 4 tracks, I'm sure many of us will have an opportunity to collaborate. And we don't want to design it as something that will just happen in a place like Nairobi, but we want to create a movement that will happen across the entire country. And I'm looking forward to having engagements and working with as many partners as possible. And everyone has a chance in moving an idea to market. Thank you.
I like that. I like what you say about everyone is an innovator. There's this guy who appears on TV several times. He's trying to make a plane somewhere in Kasarani, I think. He's trying to fix a plane. He flies it. It always falls. And, people laugh. But I think for innovators like that, sometimes we just need an enabling environment that allows you to make mistakes, that you can actually make mistakes even from startup level, that you don't set up and then we need tax from you immediately. We need, if you want to wind up, it's a really difficult process. I think we need to get to a point where the policy environment, actually appreciates that we are innovators. We make mistakes, we stumble sometimes, especially in the first few years, but then there's a way in which we can accelerate that particular innovation. So I like what you say about the work that you're doing and what you intend to do with the Innovation Week.
So as a foundation, just to respond a little bit to your issue, is that if we are not prepared to fail, then we're not prepared to innovate, because it has to be an element of a lot of trial and error and trying to figure out what exactly might work. I mean, it didn't take one experiment to create a bulb. It was an iterative process and a lot of mistakes here and there. And the reason why we established, let me come to the Innovation Week concept. The reason why we established this is, some of us probably were not even there when Kenya got independence. And sometimes when we celebrate independence, we probably don't even relate exactly what that means. Now, yes, we got independence and we do have national celebrations, but then we don't quite find celebrations that are futuristic. We have a lot of celebrations that are thinking backwards about what happened. Now, many people have been born over the last 20, 30 years, and they're struggling with jobs. They're trying to figure out how do we create opportunities for ourselves and so forth. So we're trying to carve the Innovation Week to be a more futuristic celebration. This is what I've accomplished, and this is what I might be able to accomplish. Now, then, in order to succeed, we have to think about how many things need to be addressed around that issue for you to succeed with your innovation or invention. It might be to do with the policy issues. It might be with the national legal framework. It might be with institutional, because I see scenarios where professors would hesitate or individuals would hesitate to commercialize their thing because they feel somebody might exploit it. Or it could be an issue of how is the national framework of incubation? How many incubators do we have every county? Right now we have over 100, but then the question is, where is the concentration? And what are their areas of focus? What are their priorities? If I'm right now in Garissa and I have this thing about the skin of a camel, and I think I have some intellectual property, where do I go and where will I get the expertise? So we are looking to build the Innovation Week as a national movement that then gives us our ability to focus on the issues that enable us to move ideas into market, and then ask ourselves, what are the issues around it that we must address? Year one, we might be able to address X. Year two might be Y. And by year 5, we've addressed substantial. And the goal is to build this into an international platform that keeps an eye on Kenya on an annual basis at a particular time. And everyone across the country should have a reason to participate. We will want to have as many activities as possible in the innovation hubs across the country, in universities, in counties, in development authorities, and so on and so forth.
Thank you very much, Dr. Mwansa. That's really good to hear. So if you want to plug into the National Innovation Week, please be in touch. Let us know as well on the chat. Also, the website, Kenya, I think .go.ke has all the information that you need about that. I'd also just want to ask, for those who are joining us, I see Julian, who's joining us, is an independent film producer from Uganda. We have a few people joining in from Tanzania. What's the approach of your government towards innovation? Do you have a national innovation agency? Because that may, offer a home for the startups and for innovators. Thank you very much, Dr. Tony Mwansa. Now we go to Edward Sigei. Mr. Edward Sigei is a humorous man. He is the CEO at the Kekobo, Kenya Copyright Board. I look forward to you, taking up this session, the next few minutes, to give us both humor and intelligence. So please, the floor is yours, Mr. Sigei.
Asante sana, Linda. Thank you and your team at Lawyers Hub for hosting us this afternoon. And when you are going through the list of attendees, it reminded me of how old I am, because it sounded like the Salams programs on KBC. But I was hoping you would end by ujumbe ni kwamba hakimiliki ni kitu cha muhimu. But anyway, you didn't reach that stage yet, maybe at the end. But yeah, I have 2 quick thoughts and just 1 comment. The first one is that all of us, when you hear copyright, you should always link it directly to culture, arts, and technology. And your life will be simple by that. So And it's very important that you distinguish copyright from the other IP. Copyright is deceptively, it looks very simple. And while I was undertaking my studies for my LLM, I thought it looked, all the answers were there until I went into the practice of copyright. And the complexity now emerges. And therefore, all those of you who need the services of copyright and copyright lawyers and IP should not shy away from asking all the questions, what someone would consider to be a foolish question. Please, I think we always meet new things for which we don't have answers, and we have been in the field for many years. So imagine an entrepreneur who is coming in, wants to register copyright, probably have a trademark along the way. It's like a fast-moving river where somebody feels they might drown. So it's very key to have a professional to support you, and the institutions that are here, and KIPI and SEA, are always ready and willing to interact and engage with you to go through this process. We once undertook a process of trying to support entities, first from having an IP audit, and then identifying and registering the IPs and advising them on securing the IP through licensing. And it was complicated for many of them, and a lot of them dropped out. So it's quite an unfortunate experience, but I think there is a way, we need to think of ways in which these people can really feel comfortable working with us in a journey like that, because it can be challenging and the fees can be a problem. And the second thought is that we should always, copyright is a common man's IP. Everyone of you must have had an IP of copyright nature. You have written something, you've drafted, you've drawn something, you've carved something. You are a copyright owner. Probably then, since you don't know that you are one, probably then you have never moved on to commercialize, which is very key. So having an awareness of intellectual property and the areas for potential commercialization are very, very important. And I think and that's the role of our organizations. So I think for me, I would like to extend an invitation to anyone who is on this call to connect with us if they would like to have a session on training and awareness on intellectual property generally, or on copyright. We are welcome to work with us. If you'd like to have a session to train, because some of you are experts in your areas, we can also have a training arranged. And lastly, the being common mwananchi's IP. I think we need to support copyright. I think people always equate copyright with music, which is quite wrong. And in many cases, I've had people calling me to say, is that Kenya Music Copyright Board? So we need, there's a lot of work to be done, and we can all work together to ensure that the job is well executed. Once again, thank you to Linda and her team, and I wish you the very best in this afternoon session. So it's a process, it's a long process. Thank you.
Thank you very much, Mr. Sigei. And I agree with you. We equate copyright to music and books. And now we have software as well. because the young generation is coming up with a lot of softwares in their businesses. So if you're thinking through a CRM that will be able to help your company, have good internal processes, you also need to think about, how to protect it and also how to commercialize it. You'll be able to even license other organizations to use the same CRM that you're using, for example. So thank you very much for that, Mr. Sigay. And we go to the final speaker in the first part of this session is the Vice Chancellor of Riara University, Robert Gateru. Please, the floor is yours. I'm sorry if I messed up on the titling, just forgive me. You're on mute, I think. Yes.
No worries at all. Linda, thank you so much for that. And thank you to my colleagues and friends who've spoken before, Dr. Mwanza and Mr. Sigay from Kekobo. Mine, I'll try and be very brief because really we want to be here to discuss and really ask ourselves some very serious questions about this area of intellectual property. Just briefly, for those who may not know Riara University very well, we are a private university, very dynamic, young, but making an impact in different ways. And we rely strongly on partnerships. So we are glad to have this partnership with the Innovation Agency as well as Kenya Copyright Board to really drive this agenda forward. Our motto is nurturing innovators, which is apt for today's discussion. And our mission is to empower lives. And so we strongly believe in youth empowerment. But I think as we discuss today, one of the questions that I would wish to have tackled is that, first of all, Kenyans are very creative. We all know that. Something small happens and we see all manner of things, people trying to dissect the matter completely or coming up with many other ideas that we have seen. But perhaps not many even know that or what copyright looks like. Perhaps some do things assuming it's normal or thinking that, oh yeah, I'm just moving along. But there, in other jurisdictions, every commercializable idea is taken very seriously and protected as quickly as possible before somebody else rushes to take it. And we've seen this even in the education space where our students are invited to all manner of forums to discuss or give ideas or competitions. And they give a lot of ideas, and these ideas are taken by other people and they go to commercialize. We were having that conversation with Dr. Mwanza and a few other members last week. So how do we get our young people, and not just young people, but even the older ones, to sort of realize what copyright looks like, the steps they need to take to protect it very quickly, and be able to commercialize that intellectual property. The second thing is, even getting young people excited about these kind of opportunities. Because from the first poll that was done today, and I agree, actually, Linda, when you were reading the names, I also remembered those salams. I was not a member of any salams club, but I used to really enjoy that. But looking at the people who are in this forum today, I would have expected to see a lot more young people and artists coming to engage in how they can protect the intellectual property. And I know many of them have, because I've even seen some students from Riara or alumni on the chat. So how do we get young people to coalesce and be interested a lot more in these kind of conversations? Because it's a matter of life and death for them. They could be sitting on an idea that somebody else commercializes and makes billions or millions of dollars. So, but we are not seeing a lot of that. So it's like we have to keep reminding and reminding and reminding them to have this conversation. So personally, I would be interested to hear more about, and we are also in this, how do we engage and escalate this conversation even to the classrooms, even to the lower levels of education, the primary schools, the high schools, because ideas come from as young as anybody can be. So we look forward to partnering more with the partners who are here, and I wish everybody a happy World Intellectual Property Day and very fruitful discussions today. I'll leave shortly, but I'll join again in a few moments, and then hopefully we'll be together till the end. But I'm also here to learn. Asante sana.
Asante sana, Vice Chancellor. We sincerely appreciate your presence today, and I agree with you. We need to innovate and encourage the young people. And for the older people in the room who are feeling like, we are not expected to innovate, we've seen the trend now with startups. Startups are actually doing well when they're founded by 30-year-olds and over. And so that means that you being older does not mean that this is not going to work. And I want to give you a challenge. If you're in the room, is it possible to innovate something between today and next year, the World Intellectual Property Day? Can we hope that within this 1 year span that you'll be able to have come up with something, an idea, a software, music? We've seen how America, just the US exports its ideas through movies, and we know them, we get into their culture, from the sort of laws they have around intellectual property. So I hope that we'll have such strong laws that, will help us to also export and commercialize the ideas that we have. If you have a question, use the Q&A tab. I'm seeing a lot of questions as well. I'm seeing on the chat, and it's good to see Juliet Muiruri, as well as Tati Engineer, and some of the questions have been answered as well by Dr. Isaac Rutenberg on the chat. We want to break it down for you. If you're coming in and are wondering, how do I actually commercialize my idea? So the next session is going to be a presentation to just give you the various options in which you could, commercialize your ideas from, idea to market. So our three speakers have mentioned a few sort of areas that you could, think through, but we want to just make it this more systematic for you to get the, a few minutes of how to commercialize your idea. So please take notes and think through that particular idea that you have and how you can spin this off to ensure that it's actually commercialized. And so I think at this particular point, I want to invite my colleague, Rispa, Rachel, who's going to be taking us through the next session. Rispa?
Good afternoon, ladies and gentlemen. I hope you're well. My name is Rispa. I'll be taking you through a brief presentation with regard to commercialization, just so we know a little bit more on this topic before we get into the how of proceeding with regard to commercialization of IP in Kenya. So first and foremost, we're just going to look at the terms that you're going to be getting in this topic, the terms that are going to be coming up. Of course, intellectual property is one of the terms. It refers to the creations of the mind, that is inventions, literary works, artistic works, designs, inventions, and all these that are used in commerce. We shall be hearing a lot about copyright, that is the rights of the creator over their literary and artistic works. We also have musical works, and then we shall be looking at patents, which is an exclusive right granted for an invention, a product or a process that provides in general a new way of doing something or offers a new technical solution to a problem. Technology transfers is another term that we shall hear a lot this afternoon, which is the movement of data, designs, inventions, materials, software, technical know-how, trade secrets from one organization to another or from one purpose to another. We also have IP valuation, which is the process to determine the monetary value of any subject IP. And lastly, the key term IP commercialization, which we shall move on to the next slide. That's where we are going to begin. What is IP commercialization? It is the process through which a firm creates economic value by the conversion of knowledge, discoveries, and inventions into products and services. So many times this requires additional research, it requires development, that is product development. It requires additional techniques. And to this end, it's where you will find that inventors and maybe creators sometimes lack either the skill or the resources that they need. And so that is where they need to bring on board other people or bring on board partners and different institutions to just come and take their invention or their creations to the next level. And so to pair with IP commercialization, technology transfer comes in. So this is the first step to commercialization. That is the movement of data, designs, inventions, materials from one organization to the other. And it's usually just the formal transfer of rights such that they're able to be used and commercialized and taken to the next level with regard to having a product or a service in the market. Now, the danger that has been arisen from technology transfers, or rather one of the critiques that have arisen, is the issue where there is a power dynamic between either the inventor, creator, vis-a-vis a corporation, or vis-a-vis an institution that is coming in to elevate the product or elevate the invention. But in the inverse, technology transfer has been useful in helping inventors, in helping creators just be able to commercialize the product, be able to put it out there to let their skill or the innovation go worldwide or to the next level. Now, why IP? Or why IP commercialization, sorry. So 3 main things that we established is community benefit. The public will have access to the knowledge and the processes that are going to be put out there. Revenue generation, that is for the IP holder and even the partners that are going to be engaging. We have also reward innovation, where the rights owners are able to be rewarded for their innovation and the inventiveness. So the vehicles that have been used primarily for commercialization of IP, or rather the most common channels that we see, we have licensing, we have the creation of spin-off companies or startup companies, we have franchising, and we also have sale and assignments, joint venture agreements, and IP exchange agreements. So now we're going to just briefly look at the process that you're usually going to undertake as you seek to commercialize your IP. So we have the first stage, which is the inception stage. At this stage, a lot of screening is going to be done, evaluation, just trying to look at your innovation or your idea and see whether it has any value, whether it brings any commercial value. And then research and development, which again is just going to be looking at the technological advancements or needs that can be arisen from your invention. And then we're going to, after that, you'll go to application. So this is where you'll either file your patent or any IP protection that is necessary to secure your invention or your idea. And then you will next move to financing. Now, under financing is where you engage stakeholders, partners, people who can just finance your idea, offer funding, and be able to help you process the entire process. Then we have partnerships, which is more or less with regard to financing. So the thing about partnership is it can come in various forms. So it can be a different sort of engagement, whether technical knowledge. So it doesn't have to be fixated on financing. And then there's going to be further research and development, and then integrating of IP tools, whereby if at all they're only, in the instances where it's not just one IP that will be necessary in the entire cycle. So you'll find you may need a patent, and then further you may need trademarks, you may need copyrights. And so that at this stage, that is where you're going to be focusing on that. And then lastly, there's the issue of IPR enforcement, that is IP rights enforcement, just ensuring that the system you're in, the ecosystem, offers protection for your IP, because we find that many investors, wouldn't like to be involved in situations where there's no given protection or enforcement mechanisms should there be a dispute or anything of the sort. Next, so we took some time to just look at the different situations in different jurisdictions with regard to commercialization. And so we looked at the US, we looked at England, South Africa, and China, and we were able to get a bit of statistics with regard to this regions. And so you can see that they have, many of them have IP laws. Specifically, the US has one really that is focused on IP commercialization, as well with England and South Africa. China has adopted the same system that we have, where there are different laws governing the different IP rights. And so if you look at the implementation offices, they also have implementation offices. I think also it's segmented in our country, where the different IP rights have different offices that you can look to. And then if you just look at the number of patents that have been registered, in the research, we mainly focused on research institutions and public universities, private universities. So we haven't really looked at companies, but this can just give you a brief overview of what the situation is like. So the patents that have been registered, as you can see, the US has the highest number. South Africa as well has been improving over the years in comparison to previous years. And then the case in Kenya, as we shall see shortly, is also improving gradually as the decades go by. And then we have also an increase in the number of inventions, the number of startups that are coming up as a result of this, technology transfers, and also the commercialization aspect. The kind of expenditure that is set aside, as you can see in the US, it is quite huge. That is $476 billion that is being invested into commercialization, research, development issues, and as well the revenue generation is fair in the countries as well. So we shall look at the case in Kenya. When you come to Kenya, you will see that as of 2010, this is World Bank data, 0.79% of the GDP is what was being injected into research and development. That is as of 2010. But if you look at the data, you'll find that in the past decade, that is 2001 to 2010, there was a gradual increase. And so the expectation is that between 2010 and 2020, there has been an increase of the same as well. And then data also shows that innovations by students and institutions across the country is what has put Kenya on the map with regard to it being an innovation hub. A case in point will be JKUAT. I'm sure we are all familiar with this institution, which has registered about 83 IP assets, that is 54 grants, and there were 24 applications in 2019. So of the 54, only 4 had been commercialized. And so that also shows that the commercialization rate in Kenya is quite low. However, the number of patents that are being applied as of 2019, it was 294. You can also check out the Kenya statistics that is on the KIPI website. You can get more information with regard to just our stats on there. So what you're going to just look at for the purposes of this discussion, we are looking at music copyright. We had already alluded to the definition of copyright. That is the right that creators have over literary and artistic works. In this conversation, we are going to mainly focus on musical works. They are protected for 50 years. And so the 2 aspects of musical works that you're going to be looking at are the masters and the composition. And so if we could just move on to the next slide, yeah. So the masters is just the original and official recording of a performance fixed in tangible medium. And then the composition is the written note, it is going to be shown in the next slide. Now, in both of these issues, we find that with regard to ownership, existing contracts need to be put in place. And the ownership can be either independent, joint, recording studios, or the recording labels. And this is one of the key things that need to be considered by artists, musicians, or everyone who are creator with regard to just commercializing the IP, commercializing the copyright. And I think another issue that is going to be coming up during our discussion and something that should be focused on is the role of CMOs, yes, with regard to just commercialization, the role that they play, that is the collective management offices. So that is something that I think we're going to be looking at moving forward. If you could just proceed. Thank you. We put in how to do your registration for copyright, because this is definitely a primary step before you can launch your commercialization. And so if you move on to the Kekobo website, you're going to be able to see the process. So you just access the website, and then you'll be able to create your account, register, complete the steps, attach your copyright works, make the payment, and then you can be able to receive a provisional registration certificate once your application is successful, and then finally your copyright certificate. Now, another issue that is going to be coming up is the issue of IP valuation. IP valuation is the process to determine the monetary value of IP assets. This is really key because of the intangible nature of assets. It can make it really difficult to value, to ascertain the price, and even in terms of just the transfers that could be happening, the different stakeholders that could be coming in the process of commercialization. And so this is a very key area that we need to that we're going to be having further discussions on, because it gives benefits such as securing finances, attracting partners, and licensing and franchising. And so some of the primary issues in conclusion that we are going to be addressing in this presentation or this discussion this afternoon will be with regard to just securing your IP, the issue of valuation and proposition, the issue of freedom of operation, that is whether it has been obtained or whether you'll be infringing on other people's IP rights, the issue of public knowledge and definitely awareness with regard to IP commercialization, and lastly, the issue of legislation around IP valuation, and then specifically around the issue of IP commercialization. And with that, I'm going to invite my colleague Selina to take us through the discussion.
Sorry for everyone who's expecting Selina, but I am Linda. Selina is going to come up in a few minutes. But thank you very much, Rispa. I think that was a really good presentation. And if you have any question around the presentation, please feel free to put it on the Q&A tab. We'll be handling the questions in the next session that Selina will be taking us through. I want to just mention two things. There were rumors, I think, this past week around Jay-Z and Beyonce buying the master record for DMX and trying to buy it back and to benefit his 17 children. And so I think for everyone who's a musician in the room, it tells you how how valuable your master is in that sense. For the software engineers, there have been discussions around your source code, and I think we'll be able to have further discussions around that even within the panel. We'll be sharing the presentation, and so just give us a little bit more time, and we'd really love to hear your feedback. That presentation is part of a report that we're putting together at the Lawyers Hub together with the Kenya National Innovation Agency and Riara Law School, together with other partners that are working together to find a good policy around innovation in Kenya that is convened by the Kenya National Innovation Agency. So if there's any feedback that you'd want to give, please feel free to comment within the Q&A tab, so we'll be able to get that particular report for us to engage in this. But as Dr. Mwansa said, we'll be engaging a bit more when the window for public participation will be open. I think also the second thing that we'd want to mention is to give a challenge to the innovation hubs. We have seen how the numbers of protections and registrations that are coming out of universities. Innovation hubs really hold the key to the next level in terms of commercialization, and we'd be happy to work with the innovation hubs in the room. I've seen Baraza Media as well in the room to just get us to the next level of IP, IP registration and also valuation. And so if you're wondering what the value of your IP is, you need to start thinking about valuation and how do you value your IP to ensure that there are actually investors coming on board. There are several questions as well that we've seen around the vaccine and people saying, why are we not able to get the vaccine? What are the intellectual property issues around it? And I think we're going to do that. And even who does IP valuation? And also I think Mr. Sigei talked about IP audits. Are you able to do an IP audit? So we're going to handle that, and my colleague Selina will be here shortly to handle those particular questions. We want to ask you to, feel free to engage with us on social media, use the hashtag Lawyers Hub, and please find Lawyers Hub Kenya on any platform, and we'll be happy to connect with you on those particular platforms. And I just want to plug in my, the person who makes our hoodies at the Lawyers Hub. I don't know that there's a way in which you could see very clearly who does this, because it's Intellectual Property Day. Would really appreciate you giving business to people who are coming up with such great things. And in Kenya, this hoodie is done by Emily. She's a really great person. She does nice hoodies and they're very affordable. COVID has hit her hard. And so I want to ask any of you who wants to make a hoodie, please inbox us. If you're on Twitter, DM us and ask for the contacts to Emily. We'll be able to share her number so that you'll be able to make anything that looks like this. She does everything and she does a really nice job. She's honest. So I just want to plug in, Emily, and everyone else, if you're selling stuff, if you love this as well, we have, Ginene, she's called Ginene on Instagram and on all all platforms. She makes very nice rings as well. She's an artist, and some of her works are also protected. So I hope that we'll be able to, promote the artists, in our midst. And finally, on music, I want to plug in Giuliani. Giuliani has a really great music called Masterpiece that's out there. I know many of the artists are struggling to pay bills. If you can buy their music, and now you can do it online, please buy their music so that we can keep them afloat on this World's Intellectual Property Day. So I think that's it. We'll go into the next panel. We have with us a really impressive panel that's coming up. We have Liz Lenjo. We also have Victor, who's joining us from Riara Law School. And we also have Sharon Wata, who's joining us from Kekobo. So I just want to give this opportunity to my colleague, Selena, who will take us from here. Selena?
Great, thanks. Hello, everyone, and welcome to today's session. My name is Selena Onyando. I'm a Tech Policy Fellow here at the Lawyers Hub, and I'll take you through the next two sessions of today's webinar. So we'll be talking a bit about the different aspects and themes that have already been introduced by RISPA. We have a brilliant panel ready for us today, and then we'll dive into a quick Q&A session where you can have all your questions answered. Remember, the questions go into the Q&A and not the chat section of the webinar. So first, we'll just have Victor Lando. He's a lecturer at the Riara University. Victor, we'd just like to hear from you, from your experience in research institution and a school as well. What are some of the issues or important things you think are worth considering when it comes to commercialization of research and data that comes from universities and institutions? Thank you.
Okay, thank you very much for this opportunity. A happy Intellectual Property Day to everyone. It's a pleasure to be with you on this webinar. My name is Lando. I teach law at the Riara Law School. I also practice law in Nairobi in the firm of Kamau Land and Associates Advocates. In my spare time, sometimes I do music. So, intellectual property is something that is very close to what I do. And I remember when I opened my law firm, my first case was an IP case, a copyright case, and that is where I got to meet Mr. Sigei from Kekobo. So IP is something that is very interesting, and it's very valuable, and it's something that I'm very passionate about. Now, back to the question. In terms of commercialization of intellectual property rights, unfortunately, not fortunately or unfortunately, the conversation currently, because we are in the probably fourth industrial revolution, everyone is talking about technology, about coding and about apps and everything. But we also have other forms of intellectual property. Like if you are someone who is into agriculture, then how do you ensure you have a sustainable food ecosystem? How do you develop plants varieties that are resistant to diseases or resistant to pests? That still forms part of intellectual properties, right? So it's not only copyright or patents or things tech. We should also open up the conversation on IP to also other aspects of innovations and other aspects of intellectual property. Now, the main challenges I see in terms of commercialization of ideas, one is, and especially even from a research perspective, because you'd have, for instance, people who do research in universities or research institutions. How then do they commercialize their innovations? So two steps actually, or two things in my view. One main challenge is employment law, for instance. If I am employed by Riara University, or rather I am employed by Riara University, and if I create an innovation in the course of my employment at the Riara Law School, who owns the IP? Is it me or is it the institution? Most institutions most contracts would be skewed in such a way that if I am a researcher and my key job is to conduct research and I innovate in the course of my research, my I would not be the primary beneficiary to a certain extent. The IP that I generate from my job would belong to my employer. So there is need then to work on employment relations, contracts, and employment law to ensure that, when I generate IP, generate an innovation in the course of my employment as part of the normal course of my employment, then I, as the innovator, should be entitled to a certain benefit out of my innovation. So that is one challenge that needs to be worked on. The other challenge, of course, is valuation of IP. There's this act called the Movable Security Properties Act, which gives an avenue for you to securitize intellectual property. Now, for I heard that a lot of us are lawyers. For those who know about conveyancing, selling land, if you want to get financing from a bank, you will go with your title document and tell the bank, look, my title document, my land is worth 10 million shillings. Give me a facility for 10 million shillings. And the bank will gladly do that. Now, in terms of IP, how do you commercialize or how do you securitize your idea, your innovation? And that is why we're talking about IP valuation, that if you have an innovation that has a very high potential for the market, then you can actually use that and approach a financial institution, and they'll be able to give you funds to be able to upscale your idea or your innovation. And unfortunately, currently, we don't have financial institutions are not averse, but I don't think they have really appreciated the value of that and how it can be done. And so it presents a challenge, because if I don't have the money to self-fund my project, or if I don't get an investor who we share the same vision with, who is able to fund my project, then I'm in trouble. I will have the idea, but I cannot be able to upscale it. And so you find that people would then sell themselves short so that they don't realize the full potential of their innovations or the intellectual property rights. So in summary, those would be, very briefly, a couple of the challenges. There's also the policy environment, the policy framework that needs to be tightened a bit. Our laws currently are big on registration, big on enforcement. But then once I register my copyright or my patent, I walk out the door, what happens? There needs to be that linkage between registration and then assisting or providing a conducive environment to be able to commercialize and upscale. Thank you.
Thank you, Victor. It's interesting. You mentioned IP valuation and securitization. Actually, most of the biggest challenge that entrepreneurs struggle with is access to financing. And that's something that the MPSR came to solve, but still they struggle because of the issue of valuation. And what exactly is the value of IP, and who exactly is doing the valuation? Now, can you trust the valuation is correct? So these are some of the challenges that we see even in financial institutions struggling with. So I think that's a conversation that's very timely. We hope soon we'll see regulations that come under the MPSR maybe to see what the evaluation process should look like. But thank you for sharing your thoughts. Next, we'll have Liz Lenjo, who is an intellectual property lawyer based in Nairobi, Kenya. We'd just like to hear from you, Liz. What do you think are some of the important things to consider based off your experience as an IP practitioner that artists or entrepreneurs, SMEs, startups need to consider when they are commercializing or looking to commercialize their intellectual property? Thank you.
All right. Good afternoon, everyone. My name is Liz Lenjo. I'm an advocate of the High Court of Kenya, practicing under the name and style of my legal studio, where we specialize in intellectual property, entertainment, media, and fashion law. So we are basically lawyers for the creative industry, and we advise them on matters IP. So some of the important things to consider for any individual or startup trying to go to the market always first include the kind of steps that you take into consideration when you are putting together the idea. What is the process of innovation or creativity? Are you having partners surrounding you? What kind of arrangements are you having as regards this partnership, and how do you solidify them? So what we've been seeing is many people shy away from contracts. For most of the creatives, we have seen that they feel like when they introduce formalities, it interferes with the potential of their business arrangement, or maybe their friends or their potential partners will shy away. So you'll find most times during this process of creativity, they don't have any documents in place because of that fear. So first things first, it's important that those documents are in place. If you're in the music industry, you want a split sheet in place that captures who's the composer, who's the author, who is the arranger, and of course, capture what is your relationship with the record label, so that then you ascertain as well, what are you paying for? In our industry, we find that people are paying 5,000, 10,000 to record in a studio. They're just given receipts, no contracts are in place. So the question as to who owns the sound recordings, again, is usually just left in the cloud, with the exception of a few record labels that actually, or producers that give out these contracts, which are clear. So it's always important that when you're paying for money, paying for a service, especially in the music space or in any IP space, ask yourself, what am I paying for? And have it, put it to paper or something. So it's always important that that happens. If you're going to collaborate, say for example, what we see in the software space, we'll find that there are people who have very exceptional ideas that envision using software, for example, but they do not have the expertise to create a software to do the source code and everything. So they find them partnering with the software developers and software engineers. And then in the beginning, they do not have those conversations around, okay, so what happens once we are successful with this product? So we have seen that when there's lack of agreements between these parties, then you find, the developer may disappear and go and commercialize to the exclusion of this particular individual who helped conceptualize and put together the software. So contracts are very important on the onset, in the beginning. Then once you have these agreements, then it also advises now the next step when you're going to protect and register your IP, if it's copyright, if it's a trademark, if it's a patent, if it's an industrial design and all those. Then based on this agreement, you're able to agree whose names are appearing on these IP certificates. Because again, we have seen in such cases where an agreement initially was not was not concluded, then during the registration process, either the registration is going to be fought or challenged. And then of course, this just delays that whole purpose of trying to take this particular asset to market as the next step. So again, you see contracts in that instance become very important. Again, during this process between inception and registration, I think it's always important also to have a team around you. We're talking about a legal team, a marketing team, so that then your process is foolproof. It's also speaking to the market. It's also relatable to the market and can easily be, can catch up basically and be lucrative. So again, this notion that you can do it by yourself, it is a really misplaced notion, because it takes teamwork to make the dream work, as much as it sounds so cliche, but it's the truth. So we need to focus more on building our capacities. You're not a lawyer, find the right lawyer to assist you in your business with IP, in any other area of law. It's always important to have a team with marketing, have the same done. And I think one thing that needs to be shared is what is the role of an IP lawyer as well during this process. And one of the things that IP lawyers assist with is as we interrogate the novelty of your creations, we are also looking at this creation of yours in light of other competing brands or other competing products, and how then you position yourself. Before you even brand and put out your product out there, does it reach the threshold of a trademark, for example? That logo that you have designed, is it likely to be challenged because it looks similar to another brand? So we help also save your business some time and money in terms of trying to get some things protected, and perhaps you're infringing on another party's rights, or you have contracted someone who ends up just taking advantage of you as a business person and decides to leave things off the internet and pretend to have, created them for you. So that's another situation. Something else that's also important to be considered is once you have registered all these, assets that you have under IP, what is your next step in terms of commercialization? Do you want to go local? Do you want to go international? If you want to go to international, are you aware that IP is territorial? And with that information, then you are able to now decide and designate. So in IP, we do what is called designation. We decide which areas or countries you would like them to further, spread your wings. So which means then if it's I'm going to do business in Uganda and Sweden, I'm producing in China, then you want to protect yourself in China, your country of production, you want to protect yourself in the other countries where you're going to commercialize.
Okay, seems we lost Liz for a second there, but
people will only concentrate on costs. Yeah, sorry about that. Can you hear me now?
No worry. Yes, we can.
Yeah, so I was just saying that now it's always important that they think about that whole chain, the value chain, and who has access to what, and the kind of contracts again that will be in that place to protect yourself. So I think the basic challenge has always been the protection and how to protect ourselves. We rely a lot on the registration, but we forget that there's all these other supporting structures around us.
Thank you so much, Liz, for your great insights. I think you've created a great segue into the next part of our session. Before I introduce Sharon Water from Kikobo, I'd just like to mention that, remember guys, that the chat is available for networking. Liz has mentioned opportunities that exist for a lot of lawyers as well in intellectual property. Artists are looking for lawyers who can help them register their IP, look through contracts. So if you're looking to do some pro bono work, drop in your contacts in the chat and you can engage further with the artists who will engage with you. Next, we'll have Sharon Water from the Kenya Copyright Board. She'll just come in and share also a few of her views around what she thinks are important to consider around IP commercialization, especially looking at the copyright aspect. Thank you, Sharon. Take it away. Oh, it looks like you're on mute, Sharon. Okay, perfect.
Can you hear me now?
Yes, we can. Thank you.
Okay, good afternoon. Happy World IP Day to everybody. Thank you for having us, Lawyers Hub. We are grateful to be here. Just building on what my predecessors have discussed in terms of IP, as Kekobo, as you know, that our role is to administer and enforce copyright in Kenya. My CEO had already alluded to the deceptive nature of copyright, where people don't usually know exactly what copyright covers. But in the first presentation, we had been told that copyright covers several things, which are musical, artistic, dramatic works. And so today we want to focus on musical works. So when I think about musical works, when you think about a musical work, it gives rise to different kinds of protection, because you have the music composition. So you have the author of that music, the person who writes the lyrics, that's the artist, the person who writes, the songwriters, the composers, the lyricists, the arrangers. So that's one part of the artist. Then you have another person who's the performer. You have musical instrument players. Those ones have related rights, but they also have rights in that musical composition. And then of course you have the sound recording, which is also a product of that production. So you have music publishers and producers who also have a right in that music. So when you think about commercializing this music per se, you're thinking about several income streams. One of the income streams would be from public performances, maybe on radio, maybe on television. You will have downloads and streaming online. You have live performances, you have concerts. Of course, in this pandemic season, that has been difficult to do. But I guess there are people who have tried to do that online. I know of a gospel artist who has kept it going. So I think they do a recording and they still have their day where they seemingly are having a concert, but it has been done as a recording. Then you have music that is played in several places, bars, shops, salons, anywhere in public where it's played. So this is an income stream, but this then would come through the CMOs, what you call the collective management organizations. Again, the lady from the Lawyers Hub had alluded to this and said, we are going to clarify what these are. Then you have income from the mechanical licenses when recordings are distributed on physical sound carriers, of course, like CDs, cassettes, DVDs. You also have income from synchronization licenses when the work is synchronized to visual images or videos or films. That's another income stream. Then you also have licenses and assignments. You can license your music, you can assign your music. That's another income stream. So there are several income streams that an owner or an author or anybody who has rights, copyrights in music can get. Now I'll talk about CMOs. I already said that's one of the major income streams. These are just organizations that belong to the artists that usually would collect royalties on behalf of the artists and then distribute these royalties back. So these CMOs usually they have their mandate is like in four parts. First, they need to monitor use of your work. They need to negotiate licenses on your behalf. They need to collect royalties from the users of your work and then distribute the royalties back to you. The Copyright Act that we have now allows for creation of CMOs, so to speak, which are then supervised by the Kenya Copyright Board. It's a bit defined in the Act. There are several acts that we can do, but majorly is to just know that they are doing their work well and the artists are getting back what is due to them. So the Act provides that this organization, you can only have one organization in representing a certain right. So in Kenya right now, we have three. We have an organization that presents the composers, the authors of music. We have an organization that presents the performers of music. And then we have an organization that presents the producers of music. So basically these organizations will now get that income stream from the several things I had mentioned, maybe from matatus, from bars, from public performances. Once they license these people, get back the money and then they distribute the money back to you. My friend Liz mentioned on the issue of contracts and the way most of us do not like to sign contracts. There's another income stream that musicians, so to speak, can get in terms of assigning or licensing their music. So licensing, basically, when you license your copyright, you are giving out certain rights to somebody for a certain period of time. So I can license my copyright to you maybe for 3 years. I say, use this song, exploit it, get as much as you can from it. But after the 3 years, then the copyright reverts back to me, then I can do whatever I want with it. But assignment is like you're selling off that copyright, which is still allowed. When we talk about copyright gives you two kinds of rights. So there's the moral right. This is basically the right to claim ownership, the right to be known that Sharon Wata is the singer of this song or the writer or the owner, the right to object for your material to be used in a manner that would prejudice you, maybe your reputation. And then for cases like authors who write books and whatever, you also have a right to write it anonymously or pseudonymously. This one happened a long time ago. There's a time, for example, in Europe, women were not allowed to publish. So you will find that somebody would have to write a book and publish under a different name. If you've watched Out of Africa and you know the story of Karen Blixen, she wrote books, she wrote novels, but she would write from with a man's name, because at that point a woman was not allowed to do that. So that is that right also, that's a moral right. But then now you have what you call the economic rights. So basically you're the one who can control how your work is used. And with that, I mean reproduction of your work, communication to the public performance, sale, hire, rent, and whatever. So again, since you're the one who can control the doing of this, you're allowed to license that right. You're allowed also to assign that right and get some money out of it. I don't know if I'm out of time because I'm now seeing you, Selena. Nodding.
Yes, actually, you've done a great job, Sharon. We're just trying to have enough time for the Q&A, but I think there's actually so much to unpack. It just shows that we need to be, these are conversations we need to have more often. So thank you so much, Sharon, for sharing your views. We have about 10 minutes for the Q&A. We'll be taking one live question from the audience. So if you have a question, please feel free to raise your hand and a member from our team will select you to unmute and then ask your question. But we also have some questions that are in the Q&A. So we'll read out some of the questions. We see that some have been answered as well during the course of the webinar. So we'll read some of them out and our panelists can engage on them. We do realize that we're short of time, but we understand the importance of this conversation. So we'll have maybe follow-up sessions. We'll see how to make that happen. But we have Ivan Derek Matende has raised his hand. So Ivan, we'll ask you to unmute and then you can go ahead and share your question. Thanks.
Yes, good afternoon to all of you comrades. I'm joining in for this meeting from Uganda, Kampala. I want to thank everyone that we are commemorating World Intellectual Property Day. However, I'm trying to inquire more. Could the lady that just tried to elaborate between moral rights and economic rights in regard with the musical performances draw a clearer distinction between moral rights, related rights, and economic rights in regard with the musical performances or musical rights? That's my question. Thank you.
Great, thanks, Ivan. Maybe we can take one more. We'll take one more. We have Wani Stephen. So you can go ahead and ask your question.
Okay, thank you so much. My name is Wani Stephen. I am a researcher of information technology and intellectual property law at University of Sussex in the UK, Brighton, UK. So my question is mainly, I don't know to whom to point exactly, but I think this is the right platform. The lawyers have, considering the work that you do between tech and law. So my question is artificial intelligence and intellectual property law. We know that there is this concept of personhood that basically requires an inventor or an author to be a person. But I don't know, in light of the recent development in artificial intelligence and especially the recent case, the Dabus case in the UK, and the rejection of the inventor that was made by artificial intelligence. I don't know whether the systems in Africa, or more specifically in Kenya, what is the practice in Kenya? Does it allow for for non-humans to maybe be recognized as authors or inventors, or no? Thank you.
Thank you so much for the question. We'll have we can have them answered in good time, but we'll just pick one more so we can from the chat, so that we can have all the questions coming at once before we proceed to have our panelists answer them. So we have a question from Christopher Kiragu in the Q&A rather, and he states that Kenya is presently renegotiating regional and international trade agreements. Given that other jurisdictions, more particularly US, European, and Asian countries, are more attuned to protecting their IP, are there groups lobbying for or actively engaging with the government to protect Kenyan IP interests in areas such as collaborative research? So maybe we can have Mr. Wando take the second question and the third question, and then we can proceed to the first question from Ivan taken by Sharon, and then we'll take a few more after. Thank you.
Okay, let me attempt an answer. The question on artificial intelligence, is that the one I'm supposed to answer? I think so. It's a question on artificial intelligence and whether the registration regime in Kenya would, or rather even in Africa, would allow for a machine, so-called, to be able to be registered as the author of a work of intellectual property. The whole, coincidentally, I'm also into technology and AI and things like that with regards to the law. Now, the registration of IPs can be either by individuals, natural persons. I mean, application or registration can be by individuals, natural persons, or by companies, artificial persons, depending on whether it's a patent or it's another form of IP. But the author being a machine, who owns the machine? So I think that would be now the way of going about it, that who owns the machine that has created this novel thing. In my view, it would be either go to the owner of the machine or the person who's responsible for creating the machine, so to speak. Our laws are still they're still following the technology. Unfortunately, the law here follows technology, and probably the law everywhere follows technology. But it just points that there is a gap, or there is an emerging area of practice about the effects of AI and the effects of technology on the law. How does the law then respond to things such as AI? But currently, I know Sharon can also chip in. Currently, when you go to Kekobo to file, for example, an application for copyright, it will ask details of who this person is, their name, their ID number, or the PIN, and things like that. So a machine, AI, will not have those details. Secondly, about the first question was on research institutions, and Selena, please remind me. The first question, I think I have kind of forgotten about it slightly. The other question I was supposed to answer is the second or the third question, if it could be repeated.
Oh, so we had a question around what do trade agreements look like now that we are coming into all these renegotiations, and what effect will those have?
Oh yes, and is there a lobby group that is keen on following up with the government when they are engaging into this trade agreements? I know, for example, that Kenya is part of the East African community, and there are those trade agreements that are being done within the EAC level. There are also the African Free Trade Agreement that is being done to open up Africa into one free trade area. We also have the bilateral agreements that are being done between Africa and the EU, for instance, and also during Brexit, Britain is negotiating its own bilateral agreements with different jurisdictions. So ideally, we have the Ministry of Trade and you have the Ministry of Foreign Affairs and all this. But then in terms of IP, it is not very clear. And especially with regards to something like very important in terms of national security. For example, food security. KEFIS is there, yes, but do we have a movement, that seeks to look at things as simple as food security and the IP that is generated from the agricultural sector? Because food security is a national security issue. How will it then influence our agreements with the other trade partners? So I cannot really give a clear answer. I'm just saying there's a gap there, and there is need for Kenya to take that up, and there's need for even research institutions like ourselves. I know Strathmore, our neighbors down the road, also have a very robust center for IP, and that opens up then avenues for collaboration, because as you said earlier in the presentation, collaboration is a very key notch in terms of IP protection. So there's a gap there for collaboration across the continent and even nationally for different institutions to be able to collaborate together to protect IP and also just advance our national interests. Because IP is also a national security, a national interest issue, and it's not only for the individual artist. Thank you.
Thanks, Victor. Actually, Dr. Rutenberg has put something in the chat that's worth looking at. The CPIT has a podcast that airs, I think it's weekly, with Abdul Malik and Melissa on the AFTA and its effects on the region, with specific interest to intellectual property. So that's worth looking at. So I'll just redirect the question on AFTAs to Liz. Maybe she has something else to add, considering also she's a practitioner operating in the regional landscape. And then we can have Sharon come in and share a bit on the first question around moral rights and economic rights and what the clear distinction is like in the Kenyan perspective. Thank you.
Okay, I'll just add something small in terms of the negotiations around FTAs and bilateral agreements. Our government, through the likes of Kenya Copyright Board and other IP institutions, have been making call outs to various stakeholders to share their concerns as far as some of these negotiations are concerned in terms of IP and what kind of negotiations then they'll be able to make on behalf of Kenyans and business practitioners in Kenya. So I think it's also just to let people know that when you hear that government is negotiating some of these agreements, then you feel free to send your emails and your letters to the various concerned bodies. So if you are going to address matters copyright, I believe at Kekopo they're receiving emails, at Kipi as well they're receiving emails, and then there will be, attention will be paid to them. So, it can either be a letter or an email, and they'll simply address that. That's what they have been doing with the USFTA conversations, and we hope to see more of that in the other negotiations to come.
Thank you so much, Liz. We'll just have Sharon, of course, just hop back to the first question, and then I'll have Linda come in and close off the session. We do realize that there's lots of questions, but there's so little time today. Next time, we'll see how to tackle this and have a more engaging Q&A section. So please go ahead, Sharon. Sorry, you're on mute.
Okay, can you hear me now? Yeah.
Yes,
I think I'll start by commenting on what Lando had talked about AI. In the Copyright Act, when you look at Section 31, it talks about ownership. So the first ownership is vested in the author. Then when you go to the definitions in Section 2, I think, or 1, the author is described as a person who does this, a person who does this. So when it comes to a machine, I'm doubting that the Copyright Act then has provision for that. But then again, one of the conversations that has been there around AI and copyright is again the issue of creativity. So when you're using a machine, can you then say there's creativity there? The creativity belongs to the machine or the person using the machine? I don't know. Those are the conversations, Victor, that are out there. But let me come back to the question I was asked on the issue of rights. So we already said that copyright is a legal term that's used to describe the exclusive bundle of rights that someone gets in their artistic, literary, musical, dramatic works, and now software, yeah? And which are these rights? I said these rights are two. There's economic rights. So basically economic rights, so copyright is saying that you as Victor Lando, because you're a musician, I am giving you the right to control how your work is used. So economic rights basically are saying that you control reproduction of your rights. If I want to take your CD, reproduce many of them, I need to ask for your permission or pay for it. Adaptation or translation. So I want to take Victor's song, translate it into Kikuyu or adapt it. I have to ask for the permission. Only Victor has the right to control that. We have distribution by way of sale, renting, leasing, loaning, importing, whatever, but distribution basically. And then you have broadcast of somebody's work, communication to the public, and public performance. So that's what we call economic rights, meaning that when you do these acts, I gain economically from it, from my work. And then you have two, what we are calling moral rights. One is the right to attribution, so that when I sing my song, even if I sold the economic rights to Linda Bonyo, you cannot take my CD and put there Linda Bonyo as the singer. I must always be known that Sharon Water is the singer. That's the economic right. I don't lose. It can be transferred. I can't sell it, yeah? Even if I die and my family, my husband is getting proceeds out of it, it is still will be known as Sharon Water. For those in the gospel who listen to gospel music, you knew Angela Chibalonza. Her songs will still be known as Angela Chibalonza. And you see, copyright in that song will expire 50 years after her death. Meaning, since she died, if 50 years have not lapsed, then she has that moral right, the right to attribution. Then you have the right to have your work published anonymously and pseudonymously. Yeah. I can want to be a writer, a book writer, but I want to be anonymous. I have that right, that moral right. Or I need to use another name because maybe for political reasons, because maybe for the laws that are in place, I'm not allowed to do this, then I use a pseudonym. That's a moral right. Then your right to the right to integrity of your work. So for example, if I'm singing my songs and someone wants to use my song in a pornographic video, I have the right to object to that and to object to somebody distorting my work. And then the issue now of a related right, that's a different issue. There sometimes a original copyright work can give birth to a related right. So in Kenya, we assume that if you're the writer of the song, you're the singer and you're the producer probably. But you may find there are certain songs, for example, Celine Dion sometimes sings songs she has not written. So she is the performer. She has a related right in that song. But if you go and find out who wrote the song, you may find it's a different person who also is now the author, the composer, the person who writes the words, puts down the lyrics. That's the one the law recognizes as the author. Then the singer, the one who you're hearing their voice or seeing them perform, that one has also a right, but it's called a related right. Some jurisdictions call it neighboring rights. They arise from the copyright, although they are also on their own rights in their own respect. So that's the distinction there. I know we have little time, but I hope that the person asking got that. But also, Linda, maybe you can forward more questions to us at Kekobo, and then we can always respond by email or whatever.
Yeah.
Thank you.
Thank you. Thank you very much, Sharon. And I think that was really useful to expound from that particular question. It was very useful. And I think when you start talking about Celine Dion and other musicians, I kept thinking about, there's this story about Makadem. It's called Makadem, who did the Luo version of some Kikuyu song, you know. So I think if you check out that case online, it's a very interesting case. He was doing some Kigosho song, which really hit in the Lakeside city. So you can check out that to see some of the, sort of use cases or examples. And Liz is going to add in something for just 1 minute. And I want to appreciate Tom Magari, who's made some really useful comments around the, the question on can non-humans own IP? And there was I think the case, I think it was reported on TNN. And I'd like to just ask Tom to share the same on the chat, where the monkey took a selfie, if you are alive at that particular point. Yes. So Liz, just a quick comment, and then we wrap it up.
All right, so just a quick comment on the question on copyright and related rights in music. So remember, in copyright, we have first the parties who contribute to the copyright of a song. So we have the author who writes the melody, who writes the lyrics. Then we have the composer who creates the melody itself now. And then we have an arranger who's also a copyright author or owner, where they assist in arranging the song. This is where you sing, this is where you ad-lib, or like they basically are the ones who direct kind of the song. It's called arranging. So these three parties are the ones who appear in the split sheet as the copyright owners. Again, they now, depending on how they agree or their contribution, they're able to say, as the author, I would like 20% or 30%, 40%. So that split sheet would then culminate the copyright among these three people as 100%. So, but sometimes you find that there are so many other, or there can be 3 authors, 2 composers. So that's what the split sheet helps with that. And then now we have also the publisher, where now this copyright can be assigned to them by way of a publishing agreement. And then once that happens, you'll find that then they will appear also in the declaration forms in the CMO, especially Music Copyright Society of Kenya. So of course, it means that now these rights holders, the author, composer, and arranger, sometimes they may be one person, sometimes they may be more than one person. The kind of arrangement that they have with the publisher should be carefully negotiated, and then mirrored in any other spaces that they will be negotiating or getting commercial opportunities for the songs that have been written by these three parties. Again, it's always important to know that publishers try to tell people that it's a standard way of doing business. A contract has to be negotiated, so don't get duped into signing a contract without negotiating. If you don't negotiate, then it's not a contract. Then the related rights, we have the performer. We have now been seeing a rise in hybrid split sheets where we'll divide them in the various sections. We'll have the copyright section and then the performer section, which now will capture the various performers, the singer, the rapper, the sessional musician. So if you have someone playing the bass, you have someone playing the keyboard, you have background vocalists, all these are captured. We also have the studio producer. The studio producer has been confused by the producer, who I will just allude to shortly. And the studio producer, you find that they have gained this name studio producer because of that fancy gadget that is found in the studio that has sort of now replaced some of these sessional musicians. They're able to play the various instruments based on that fancy machine that we usually see in studio. So you find the studio producer is actually a performer and not a producer in what now we think they are. So basically in the legal definition now, a producer who's also now the owner of the second related right, which is the sound recording right, belongs to the person financing the recording of the song. And that is why I said earlier, when you're paying that 5,000, but when you're paying that 10,000 shillings, in a studio, you need to be very clear about what it is for. In most instances, you'll find that it is just for the 1 hour that you spend in the studio and not for the sound recording right. So then that is also becomes very important to establish. So you find, again, producers will give various types of agreements. You find if you're doing a single, you may get a single recording agreement. I always advise that you as the right holder should come with your own agreement and then negotiate from there. It makes things much easier. It may be an album recording agreement if you're just seeking the services of a record label to produce that agreement. And again, now you need to be very clear if there's any payment, what that will be. And if you own the sound recording rights as well, it needs to be very clear from the beginning. And then in some instances, we have now what is called the 360 agreement, where now we have all these big record labels that try to sign artists and they manage and publish as well as record. So you find that with the 360 agreement, all the eggs are in one basket. So again, this one has to be negotiated very carefully. That is why you'll see now so many artists internationally are trying to negotiate to buy back their masters because they sign this kind of agreements. They tend to be very tedious, but please never sign a 360 agreement without a legal advisor. Especially, I recommend one who has experience in the musical industry, so that then they are able to ensure that all rights are protected and you still get what you want as an artist. So thank you, Bonnie, for that opportunity.
Thank you. Thank you very much, Liz. I think that was very useful. 360 agreements. Don't spend the rest of your life trying to buy back your master record. And we've seen from those who are fans of DMX, what's been happening this past week. Some artists die poor, and everyone else benefits except themselves. So I want to thank Sharon Wata from Kikobo, Victor Lando from from Riara University, as well as Liz Lenjo from MYIP Studio. And Liz is a really dear, part of the Lawyers Hub. So we want to thank you very much for this. I'm going to pose a challenge because we are closing. We tried to put this webinar to be 1.5 hours, but clearly it's not working. Some of us asked that we close early so that we can catch a matatu, catch a cab, whatever, so that we can get home before the curfew. So we want to just say thank you for staying on with us. There's over 300 people who came for this webinar today, and we are so grateful for your time. I just want to pose a challenge and ask each and everyone in the room. Next year, as we celebrate, World IP Day, what innovation are you going to be coming up with. Please, can we manifest? I see people manifesting these days and saying, yeah, I'm manifesting a car, I'm manifesting this. Can we manifest in the chat and just say, next year I am gonna be this person who has this, ring that I've come up with. Can you come up with a song? People want to sing in English, they can barely write lyrics. Can you be a songwriter for somebody, some artist who just maybe sings Kigosho or Luo or Kalenjin, and you can do some really nice lyrics for them. So I really want to find out on the chat, what are you going to create? Is it software? Is it a book? The VC from Rera University is saying wonderful insights from the panelists. Thank you very much. Let's plan to have other sessions. I agree. And we have seen the issues that have come up. We've seen the issues on CMOs that has come up here on actually how we are managing the artists and their revenue. We're going to forward that as well as we work on the policy. We've also seen the issues that have come up, the complaint on the timeframes. I think every single comment that was made will really take care of, take to consideration everything that you've talked about. We also just want to thank everyone who made this possible, from the Kenya National Innovation Agency. Thank you for being of support to Riara University, to all the universities that are part of this particular policy making process that we're trying to go through, as well as the team here at the Lawyers Hub, including Selina Rispa, Louisa Ken, and everyone at the Lawyers Hub. We really want to say thank you. Dr. Tonio Mwanza, thank you very much. He says it takes partnerships to move the innovation and commercialization agenda to move forward. We all have a part to play. John Patrick Okot says, I'll bring in an old idea reinvented, taking legal services to the 60% of Kenyans. There you go, John, do it. We have Faith, Tom, and I think Faith connecting on the chat. Thank you, Michelle Omwom saying thank you, Lawyers Hub, for the informative session. Thank you very much. I didn't see anybody else say they're going to do something. Next year, you need to do something. I am personally going to publish a book. Please buy it, I beg you. Buy it, but I'm manifesting a book. We can't sleep with all these ideas. The moment you leave Earth, nobody can actually remember the philosophy of the things you stood for. Lawrence Yele is also doing a book, and Janet, thank you so much for saying you will buy my book. Thank you very much. We look forward to that session. So I want to challenge you, be an innovator. Dr. Tonio Mwanza said this at the beginning, everyone is an innovator. Is it a recipe, that can only be, enjoyed at particular restaurants? Please do. Brian Mook is manifesting a movie. And John Patrick says, publish, I will buy. Thank you very much. And Margaret Gishuki is finishing 2 books by December. So Kekobo, you have a lot of people who are coming to you. Lorian is also going to buy a book. Leba Noenga is talking about an incubation center with several transformative ideas that will be a force. Let's keep manifesting, and let's do it. Fauzia Volke, I think, is manifesting an art step-by-step painting in watercolors. I like that. Let's go and innovate. And as we work on the policy space, I hope that we also work on the innovation space so that we come up with all these particular ideas. I want to also just plug in a final, there's an NFT. If you've seen, the world is getting crazy about NFTs on the blockchain. And so we have a Kenyan company that is called Picture Images. They are launching their NFT today, the first digital art NFT in Africa. So look for Picture Images on all social media and be part of that particular NFT. If you're wondering what NFTs are, please join us the next time and we'll talk about that. So thank you very much for everyone who's talking about, Juliet Mururi is manifesting a digital web show. Ashley Kibali is manifesting an educational game that's available actually on Play Store. Kato Munyaneza Silvan is talking about publishing a book. And so thank you very much. Some of the comments, I'm sorry, I can't see all of them now, but if you want to recap this session, go on YouTube, look for Lawyers Hub Kenya. And we ask you to please like and subscribe to our pages so that you can be able to hear from us. So thanks everyone. And thanks Kwame from Ghana for joining us as well. We sincerely appreciate you. And Laban Olenga, thank you. Oenga, thanks for joining us. And Margaret Gishuki, please go on YouTube. You'll find all the recordings on our YouTube page. From us at the Lawyers Hub, we want to thank you and wish you a really happy International IP Day and hope that you create something in the next 365 days. And to our panelists and partners, thank you very much. From us at the Lawyers Hub, bye-bye.